Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number
16.
16 and 17, Your Lordship.
16 and 17.
Yes, Your Lordship. Let this matter be taking up to 2 weeks, Your Lordship.
I am there.
And who is 17?
17.
Similar, same matter. Arising of the, these are similar issues involved.
Yes, Your Lordship.
Mr. Kharmi is there. Yeah.
There will be no reason for objecting it. Will there be?
No, that's right.
Anyway, 16. Just written, Miss MS so-and-so, London Counsel for the petitioner. 6. Makes a prayer for adjourning the matter. Why would you want adjournment?
Because we are not ready, Your Lordship.
Huh?
Not ready, Your Lordship.
Can it be a ground? Can it be a ground? To come with some better ground, you see. If you want adjournment, this cannot be a ground. Anyway, so-and-so, makes praise that matter may be adjourned for 2 weeks. The prayer has not been opposed by London Counsel and Counsel for the State. Okay, list after 2 weeks. Both the cases 16, 17.
Much obliged, Your Lordship.
Yes.
Maybe please, Your Lordship. Your Lordship, I beg to mention item number 14 on behalf of my senior SP Manta, who is unable to present here today as he is on leave. Your Lordship, can the matter be taken up after 3 weeks' time?
This is also 2018 matter. Mr. Mohanto is not well. Some alternative should be made.
He's on leave, Your Lordship.
There are many lawyers appearing along with him here. Just cannot go on asking time. See, we repeatedly on the same ground. This court knows about Mr. Mohanto. Okay. But then matter also you have to see what action, see for how long it can be adjourned on the same ground. Item 14. Any objection?
No objection.
This is what? This is a service matter. Is it a service matter?
Yes, sir.
Okay. A prayer has been made on behalf of Sri SP Mohantos, London Senior Counsel, appearing for the petitioner on the ground of his illness. Stop. The prayer has not been. A prayer has been made on behalf of so-and-so to adjourn the matter. Okay, on the ground. If I miss those things, you just cover up those small things and all these things. Then, London Counsel appearing for the respondent has no objection. Okay, prayer allowed. List after 2 weeks. Yes.
List, item number 1.
Please, Lordship.
Yes.
Lordship, I've sought for instructions in this matter, but I'm still yet to get.
What is the matter about?
Lordship, this is regarding that BSF matter where this BSF persons had. And there was no PP in.
They have claimed the trial of the.
Lordship, for the transfer thing. Lordship, I'm still yet to receive instructions in this matter, Lordship.
It's a simple instruction. Why?
Lordship.
It's the simplest thing. Whether, see, their prayer is that they have filed an application and that has not been disposed of by the court.
Lordship.
This is the simple thing. What is the difficulty in taking that?
Lordship. Lordship, if 3 days time can be given, I'll get the.
See, you take 3 days, you can take more than 3 days, but then make sure you take instructions.
Lordship.
For these kind of things, why should we adjourn it again and again?
Agreed, Lordship.
See, earlier you have taken 2 weeks time for instruction.
Lordship.
It's a simple instruction. There is no complication in it. Anyway, Mr. No objection.
No objection.
Mr. A. Karwanlam, London State Council, 6. Further time to obtain instruction in the matter. They are allowed list after a week. You are getting 1 week.
Highly obliged.
Item number 2.
Well, please, Your Lordship. Your Lordship, fresh steps have been taken against respond number 2, my lord. We are awaiting status report from the GPO, my lord.
Shall we wait for
Lordship.
the service report?
I think let a chance be given to the informant, Your Lordship.
This is not a POXO matter, isn't
No,
it?
no, this is
Section
354.
354, my lord. In fact, settlement has been reached between the parties, my lord.
Mr. Regime, last learned counsel for the petitioner submits that step has been taken. Fresh step has been taken for service of notice upon respondent number 2. When did you take? It's 23rd, right? You have taken on 23rd August?
24th, my lord.
No.
Step the 23rd, 24th, ma.
It's taken on 23/8/2023. The service report has not been received till date.
Lordship.
Give a full stop. Wait for service report. List after
Lordship.
2 weeks.
2 weeks, my lord. Still order
Alright.
for item number
7.
4, 5, 6, and 7, my lord.
Up to 7.
Lordship. Highly obliged, my lord.
Item number 8.
Yes, Mr. Paul.
Well, its service is complete on the private respondent. It has been served on 4/9/2023, my lords. We've taken out a printout from the web portal of the India Post, my lords.
But then you have to file it by way, because our office
file
note
an
says
We'll
our
file an
office note
affidavit.
says that has
My lords,
not received.
we'll file an affidavit.
Mr. K. Paul, London Senior Counsel, submits that service upon respondent number 2 has been affected. Give a full stop. However, office note dated 6/9/23 says that ID card on respondent number 3 has not yet been received. Mr. Paul prays that petitioner may be allowed to file an affidavit of service after obtaining status report from the postal department. Prayer allowed. List after
A week, my lords.
a week.
It's the only thing, it's gone as respondent number 2, my lords, is respondent number 3. 1 and 2 are the state, my lords.
Respondent number 3, just correct it. Respondent number 3.
Right. Right.
Thank you. After respondent number 2.
Item number 10.
Yeah, please, Lordship.
Yes.
We take steps for respondent number 1. We are waiting for this service report.
Till now.
No,
So
Lordship.
you want to wait?
Yes, Lordship.
Step has been taken on respond for service of notice upon respondent number 1, 122/8/2023. However, no acknowledgement has been received till date. Stop. Await service report. List after 2 weeks.
Highly obliged, Lordship.
Hearing.
Await service report. Give a full stop. List after 2 weeks.
11.
Yes.
May it please your Lordship. Lordship, this matter is regarding the the petitioners are advertising association, Lordship. We comprise of members who deal in the business of advertising and putting up signages and hoardings, Lordship.
Yes.
Lordship, the primary contention in this matter is regarding the policy, Lordship, wherein the respondent authorities had illegally and without authority removed the signages as well as hoardings on state highways.
Where is the policy? Where is the decision? Policy decision. There is a policy, you say. Where is that?
Well, it's the issue here pertains to, the admitted position is, state of Meghalaya does not have a policy insofar as this is concerned. I think my learned friend for the state wanted to seek instructions. They've sought instructions, and there is no policy in place insofar as the state of Meghalaya is concerned. Now, this all emanated, from that liquor case, if your lordships where the committee that was set up by the Honorable Supreme Court with regard to safety of vehicles in the highway.
So those removal of hoardings, the highway.
Lordships, it all emanated from there. So from there,
It's quite some times back, I think.
Lordships.
Then what remains in this matter then?
Well, that is what I think right now it's only remains as an academic exercise, because otherwise also, then some exemption was granted to the state of Meghalaya.
The matter itself is of 2017 and we are in 2023.
My lords.
What relief you expect from the court?
Well, because it would be otherwise
is there any cause of action surviving?
Well, it's because I would have to seek instructions insofar as whether fresh
Your association has how many members?
I'm sorry.
Your association has how many members?
Well, I'll have to seek instructions as on today.
How many of you had subsisting contract as on the day of removal? I think your petition is silent about all those things.
Lordships.
And there is an admission there are some people, those who are not also member of the association.
True, my lords.
Now, even if you ask for a blanket direction, can it be passed by the court?
Well, we were only on that limited issue that state of Meghalaya was otherwise exempt. And we do not really fall within the purview of these state roads, would not fall within the purview of any directions passed by the Honorable Apex Court.
The question is that how many of your association members
had existing
locus standi as on the day of the removal of those hoardings?
Lordships.
I think, I do not know, if you want to argue, we can proceed ahead. But then I do not know at the end of the day.
I would not want to take the time of this Honorable Court on an academic exercise. So I would pray, my lords, your lordships grant me a week's time. We'll seek instructions whether they at all want to pursue this matter.
Yes, Mr. Khan, what do you say?
Because if they are now permitting us to put signages, my lords, then pursuing this matter will be of no end. Because I've seen, my lords, that now new signages are coming across.
You are allowing now. So there is a change in the...
After that exemption came from the Honorable Supreme Court concerning the topography of Meghalaya, my lords, I think there's been some change in the stance of the government.
I think that would be a better thing, you see, like if you withdraw and say, supposing if they're allowing again, they can apply afresh.
Absolutely.
In that view, the matter, Lordship is correct. The cause of action that initiated then does not survive.
Because 2017, you see.
That cause of action today.
And I think this is something, the permission is not government. It's not a lifetime permission, isn't it?
No, my lords. It's
something periodic.
Periodic and renewable. So as the Lordship rightly said, there is a contract, individual contract. So those issues, let him do.
But if the government changes its position, then we need not waste your Lordship's precious time.
Exactly. Then you will take instruction.
We'll seek instructions.
Yes, ask Mr. K. Learned Senior Counsel for the petitioner.
This is next.
Also Mr. K. Khan, Learned AG, appearing with Mr. Sen Gupta. Mr. Paul. Praise 6. Praise for grant us time, enabling him to obtain instruction as to whether there remains any cause of action surviving in the matter. Mr. Khan, Learned AG has no objection to the prayer. Prayer allowed. List after a week.
2 weeks, my lords.
List after 2 weeks. Please see, I do not want to keep this old matters pending.
Naturally, my lords.
For nothing, I have seen there are certain files
which are just
probably you see there remains no cause of action.
Absolutely.
There's an unnecessary remaining pending.
Lordship.
Item number 12.
May it please your Lordship.
Yes.
Lordship, we are awaiting instruction as regard to whether the petition is still continuing.
Small things why you have to wait. This is not a huge instruction, will take time to arrive here. Only thing is the submission was made that on the basis of the interim order, these people are serving.
Still,
you have ousted the person because of his extreme medical category or something like that.
P5.
Yes.
They say
which
that
basically renders him unsuitable for retaining.
Unsuitability.
But then, if a person continues for more than 5 years by virtue of interim order, can your stand remain?
And that too also second term.
The only thing was to that just to inform the court that whether they are at all continuing service or not.
Lordship, some more time may be given.
See, madam, this is also another matter which is just remaining pending like that, unnecessary. You have allowed them to continue in the service, you should allow. And that liberty will always be there to assess their medical condition.
Definitely, my lord.
Always be there.
On the last occasion, previous round of litigation, they say that they themselves has withdrawn that remedy has been.
See, you can use your good office to do all those things, solve those things. It's not needed that there should be courts intervention every time. Especially when you allow somebody to continue. When? Tomorrow?
Lordship, 1 week, Lordship.
My lord, this is the second round of.
You have no other option. You have to wait.
I have no other option, man.
Because if they do not come with instruction, we are handicapped.
My lord, Well, even in the previous round of litigation, my lord, they say that remedy has been, the petitioner has been given a redressal of his grievances, my lord. And then again,
Miss A. Pradhan, Learned Counsel append to the respondents 6 further 1 week's time to obtain necessary instruction. Obtain instruction as per, not necessary instruction, as per the order dated 28/2023 passed by this court. Mr. Arjal, Learned Counsel for the petitioner, has no objection. List after a week.
Highly obliged.
Highly obliged.
Item number 13.
Yes, again Mr. Jha. Where is item number 13? Same order. Same order.
Item 15.
Okay. Please, Your Lordship. Lordship, I pray for a short pass over Your Lordship. Mr. Paul is on next.
Yes. I could not follow. Yes.
I pray for a pass over Your Lordship. Mr. Paul is on next, Your Lordship.
Mr. Paul is on his legs. Okay,
Yes.
you can start. You can do. Why not? Tell us the facts.
And the
Or you are the respondent.
earlier round of argument, he was arguing the case.
This is a quashing application.
Your Lordship, 482.
FIR.
No, complaint case under 200, Your Lordship.
Complaint case. So, what is to be done?
I can start.
He will be coming, isn't it?
Yes, Your Lordship.
So it's okay. If he comes, then we can start. Yes. Make sure you do not ask time at the end of the thing. You will not waste any time.
My apology, Your Lordship.
Yes, you can.
Your Lordship, may it please, Your Lordship. There's a broad outline of this particular matter, Your Lordship, that the petitioner here is a partnership firm. It is a firm for manufacturing of this media grinding balls. In brief, Your Lordship, just to proper understanding of the matter, they've been supplying this media grinding balls to the respondent company, the JUD Siemens. So there was an order placed by them for supply of this material. So we had an agreement that, okay, we'll supply it to them. And the agreed amount that they have to pay us was around 54 lakhs. 54 lakhs. So initially they paid us.
You executed an agreement.
Yeah. Then they paid us initially of 8 lakhs. First 5 lakhs, then thereafter 3 lakhs was paid after a delayed time, saying that
Who filed the FIA? Who filed the complaint case? Who is
the respondent company?
Respondent company?
Yes. JUD Cement.
They placed order.
They placed order from me.
There it is their duty to pay money, isn't it?
Yes. We supplied them the materials.
Okay. Anyway.
Saying that there is some deficiency in those materials.
Deficiency in the materials. And for that CR case.
For that CR case.
Anyway.
And then I'll just go through the entire annexures. Will be Lordship, Annexure 2, Lordship, 2 and 3 series. These are the purchase order, Your Lordship, amounting to rupees 55 lakhs 36,687.
These are purchase orders,
Your Lordship. Now, after these orders which they have placed, feeling that there was a financial security, they gave us post-dated checks. Your Lordship, that is at Annexure 2 post-dated checks from IDBI Bank in favor of MS Mittal, which are from IDBI Bank Guwahati. The details, Your Lordship, have provided at paragraph 4 of my...
One second, Mr. 1 minute. Here.
$13 lakhs, that is date 7/5/2016. Paragraph 14, I have indicated everything, Your Lordship, of my petition.
For post-dated checks?
Yes. Now we were secure, like since they paid us this much, so we'll finish the order and supply them. We supplied them the entire materials. Thereafter, what happened was that we wrote to them saying like, please pay the balance amount. So they paid us 5 lakhs. Thereafter there was a delay in payment. So we wrote to them to pay the balance amount. They paid us 3 lakhs in view of the fact that the company was hit by a cyclone. So there was slow flow of in cash. Thereafter, after the 8 lakhs, they stopped payment. Since we had the post-dated check with us, so we decided to withdraw the amount. And when we deposited those check bounced. Then we issued notices under the NI Act. Give them 15 days time. They never responded to that. So we instituted proceedings under NI Act before the Raigad court. Then notice was issued to them. They came and filed a revision against those orders. Those revisions were dismissed. All is on record, Your Lordship. Now they've come up with a plea that there is some deficiency in service. And we've had meetings with them.
This CR case has been filed after the dismissal of their revision.
Yes. This is like a counter blast and after.
What is the allegation made in the CR cases?
I'll take Your Lordship to that.
Anyway, please you just finish your facts. Then
thereafter, Your Lordship, they filed a revision. Those were dismissed. The matter was
all these details are provided in your petition?
Yes. So thereafter, after a gap of 2 years, we had a meeting to sort out those issues. But in those meetings, we came out to learn that a complaint case was filed against us in 2018. And then the court initially recorded the statements and issued a bailable warrant of arrest against us. Thereafter, those bailable warrants were never executed because from the records, Your Lordship, is before Your Lordship, I have perused those records. The IO had made submitted a report that they were not executed, so we're praying for a next production date. In the meantime, before that has come, the court on the mere submissions of the counsels had issued non-bailable warrant against us. And those non-bailable warrants issued by the court also, steps was never taken by the respondents herein. So after we came to learn about all these proceedings, so we applied for a certified copy, and that's why before Your Lordship. Our main contention is that there's an abuse of process of court.
What is that?
Your Lordship.
What is the allegation in their complaint case?
Your Lordship, I'll take Your Lordship.
Where is the complaint?
Complaint case is at Annexure 10, Your Lordship, page 63. Paragraph 10, Your Lordship, page 66. They say that the complaint makes it due to broken and faulty grinding media balls supplied by the accused person, the production of cement at mill factory of the complainant has been halted numerous times, and this numerous shutdown of production.
You are reading paragraph?
Paragraph 10 of the complaint, page 66.
Your agreement takes care of those part?
Absolutely, Your Lordship. And this is totally a breach of the contract.
And this complaint is under what? 406, 418, 420. 424.
What is that agreement? That agreement is not part of the report.
Yes, what else?
So they file a complaint case against us, Your Lordship, after a lapse of...
Because you did not take return of the product within a certain period of time. So that amounts to cheating.
No, nothing is there, Lordship. And in the complaint, nothing is mentioned about those NI proceedings also, Your Lordship.
It's all right, we're not much into that, but then in their complaint also, I don't know, everything speaks about. What is the stage of the case now?
The records are before Your Lordship, that's why.
This LC records are here.
Your Lordship.
What for it was called 2018 method LC record is called and it is written here.
This is a state
what for record is needed?
The proceedings.
You are not on any of the procedural access or anything. You are not on that. Your case is that is a complaint.
Yes.
And the allegation made therein
is purely of civil nature, Lord.
That is what your case is, I believe, isn't it? It's a commercial transaction. There is an agreement in existence which takes care of the.
And everything is a counterblast. It's a civil nature, and there's a limitation which involves lordship after 2 years, because
2 years of what? 2 years of what? 2 years from the date of.
After 2 years of the
2 years
of the NI proceedings.
That's not the process.
How can we 2 years for NI proceedings?
Your Lordship.
What is the limitation? What basis you say?
I won't say a limitation, but there's a delay, Your Lordship.
Delay of 2 years.
Of 2 years.
But then there is no bar otherwise.
There's no bar. But the entire exercise, Your Lordship, prima facie is an afterthought just to harass us because we are not from Northeast, and to make our presence before the Cleariat Court.
No, you have never appeared before the court below.
No, Lordship. So, Your Lordship, will not bother Your Lordship. I'd like to draw Your Lordship to which I have already submitted my written argument. We have raised certain grounds.
It was hard also.
Your Lordship. Page 8, Your Lordship.
This kind of cases, if it remains pending for 4 or 5 years and then there is written argument by both the parties.
I doubt whether they have submitted their written argument or not, because they've been praying for time.
Was there an order to that effect?
Yes, Your Honor. Orders there. Has Your Lordship got it?
Let me see. There seems something. Yes. There is on behalf of the petitioner.
Your Lordship.
The petitioners.
Okay.
Have your Lordship got it? A written argument. I'd like to take your Lordship to page 8 of my argument.
Page 8 of your
written argument, your Lordship.
Written argument.
For easy reference of the judgments which I have relied upon, your Lordship.
Yes.
Your Lordship, the ground number 1 which I have taken is that the
counterblast.
Page 8, Lordship.
Yes.
CR case number 3 is a mere counterblast with a criminal complaint under section 138 which we have filed, your Lordship. And another additional
No,
ground.
details of 138 you have given in your petition.
Your Lordship. The orders are there. And there's no specific allegation made.
What happened to all those cases?
I have relied I have given a compilation also, your Lordship. For those judgments also.
No, that about your 138.
That is at annexure.
No, these are pending, still pending, those cases.
Those cases?
Your NI Act cases.
Still pending, Lordship. The number 2 is that no specific allegation has been made against the accused petitioner here. Here I have relied upon a decision of Supreme Court, your Lordship, in 2020, which I have quoted in my written argument.
Yes, prima facie seems like a kind of civil dispute. We will see.
Absolutely, your Lordship. It's been made to paint a color of a criminal proceedings, your Lordship.
That is how it should happen. Without anything, how court will issue process.
Your Lordship. And thirdly, your Lordship, these are disputed question of facts. That is at page 11. Somebody submitted a complaint case, so and so has been filed under 200, is not maintainable. As much as prima facie, the allegations made in the criminal complaint are disputed question of facts, which is civil in nature, and it is a civil court who has competent jurisdiction. The entire basis of CR so and so is with regard to
disputed question of fact cannot be settled in a CR case.
We've made attempts for settlement, but they have not responded.
No. Well, you said the disputed question of fact. So there cannot be a CR case. Should be a civil court. So disputed question of fact cannot be made a basis for filing a criminal case.
My Lordship. Because they've admitted also there's an inferior supply of quality. In my humble submission, if that is the case, they could have approached the consumer redressal forum.
See, you may always say that there are certain things which would be of only civil consequences. You see, just the process before a criminal court cannot be set and mentioned on the basis of these facts.
No.
That would be definitely correct, you're saying. And one thing is that it's not disputed that this entire, you see, like issue arose out of a commercial transaction. Is it the case? This entire matter, whether your cases under NI Act filed by you, the CR case is filed by him, these are all arising out of one commercial transaction.
Yes.
Or maybe several commercial transactions, but then arising out of.
Why? Because they have issued us post-dated checks.
And there was an agreement holding the field.
Your Lordship.
At that particular point.
There's a breach of contract.
So where is your agreement?
Your agreement is not there, Lordship.
There is no agreement. No agreement executed with them.
Written agreement, if I am.
But there is no written agreement.
But there's an admitted fact they have ordered materials from ourselves.
So far as the commercial transaction between the parties are concerned, that is not denied. But there is no. Then what else? Anything
Page
else?
13, Your Lordship, it's my submission, page 13, that is the abuse of process of law, Your Lordship. Just to escape the liability of payment, Your Lordship.
Yes.
That is why they have.
That you have said. Once you say counterblast, that takes care of everything.
So another ground taken is the delay aspect, Your Lordship, after 2 years. That's page 14.
Delay until unless there is a bar for the court to take cognizance. What delay will have? This will not have a not cause.
But then afterthought, after all those.
If your case is basically it's totally based on facts.
Yes.
And you want to say that this in the given faction situation, there cannot be a criminal proceeding.
Your Lordship.
That is what.
And no ingredients, Your Lordship, in those sections.
That is what. Anything more?
And 17, Your Lordship. Normally, in cases like this, Your Lordship, the court at least should have issued summons.
That is okay, but then can it be a ground for quashing?
Kindly go through what I've read.
Can be a ground for quashing?
Page 18, Your Lordship.
No, what is the status of those non-billable warrants and all?
Never executed.
Nobody knows.
Your Lordship, it's in fact from the records.
Whether the proceeding before the court was
the
stayed.
report is in Hindi, Your Lordship.
It's been stayed.
It's been stayed and
It's
the
been
records
stayed
are
and the records are called.
There is an interim order, which is
yes, Your Lordship. There is an interim order.
Yes.
That's all, Your Lordship.
Yes, Mr. Paul.
Let's, if I may first take your lordships to the complaint filed by us at page 65, my lords, paragraph 7. Your lordships have seen, my lords, what had happened is some media balls which are essential for grinding clinker was supplied by the petitioner to the respondent complainant company. Now, when those media balls were used, my lords, it was found that rather than it doing the job of grinding, it itself was breaking into pieces and falling apart. Then, if your lordships, if I may just draw your lordships' attention to paragraph 6, 7 and 8, my lords, of my complaint. My lords, I'll quickly read paragraph 6, my lords, at page 65, if your lordships have.
Yes, yes.
That upon noticing the daily breakage of the grinding media balls supplied by the accused person, the complainant had sent several emails to the accused person representatives while email dated so-and-so and so-and-so, apprising of the fact that the media balls so supplied are breaking on a daily basis, hampering the production of the complainant and thereby huge losses incurred upon the complainant. The complainant also calls upon the accused person representative to compensate a portion of the losses suffered by the complainant. Thereafter, on 12 to 2017, a joint inspection was carried out at the cement plant of the complainant at Vaijar, Narpu, East Giant Hills, Meghalaya, between the representatives of both the accused person and the complainants, and the minutes of the meeting in the connection with the aforesaid joint inspection and meeting was thereupon prepared. And over and above the said meeting and inspection, the representative of the accused person had concurred that they will decide regarding the media balls. That even after the joint inspection, the accused person took no steps, my lords, to replace the broken media balls, and no response was given from the accused person, to which the complainant again sent email to the accused person representatives calling for another joint inspection, replacement of broken media balls, and to compensate a portion of the losses. That despite repeated emails being sent by so-and-so, my lords, we'll just skip that part, my lords. Letter was sent on 16/6/2016 as was sent to the accused person, apprising of the accused person of the promise of 200% assurance given by the accused person prior to the purchase of the media balls, that breakage of media balls so supplied, the joint inspection conducted, calling upon the accused person to comply with the terms and conditions as mentioned in the letter dated 11/3/2016 and to compensate for so-and-so, so-and-so. What had happened is, my lords, as happens in a regular commercial transactions, we wrote to them. There was a joint inspection held, my lords. In the joint inspection, the representative of the complainant found out that the media balls were cracking, and they said that we'll take a final call on this and have something done about it. Now, that was, my lords, in the year 12/6/2016. From 2016 till 2018, my lords, the petitioner continued writing back to them, nothing transpired. Now, what my learned friend is arguing before your lordships, my lords, if I've understood it correct, is primarily on two footings. That A, this is a counterblast. But just prima facie it is not a counterblast because of two reasons, my lords. The check bouncing cases, my lords, on 7/7/2016, as per them, my lords, at page 24 and 26, at Annexure 6, my lords, because of the bouncing of the 4 checks, legal notice was issued under 138. This is the complaint that has been filed by them, my lords, at page 27.
Yes.
So this is, my lords, on 7/9/2016.
What is the date?
My lords, I'll just give the date.
(17/8).
2016. Just bear with me for a second. First, your lordships may kindly have page 24, my lords, at Annexure 6. This is the legal notice issued on 7/7/2016.
Yes.
So the cause for the NI Act cases, my lords, arises on 7/7/2016.
What bearing this NI Act will have here? You're just countering his submission of
I am countering what my learned friend is submitting. Because he would have to come within the parameters for your lordships to exercise powers under 482. This is a criminal petition under 482. Your lordships are very well of the parameters.
No, otherwise what happens? Say, supposing if there is no disclosure of a criminal offence in your complaint petition.
In my humble submission, that will not have a bearing. Because the cause of action for this particular proceedings is completely different. What I'm countering is, my lords, that the proceedings under NI Act were initiated in the year 2016. A counterblast, if at all it has to happen, my lords, would happen within 3 months, 4 months, 6 months, that I'm trying to avoid the 138 proceeding. So I file another counter complaint against him. The complaint before the courts and Clariot was filed in the year 2018.
After 2 years.
2 years.
So there is no counter.
So it cannot be, my lords, it would deny normal prudence that after 2 years, my lords, I would wake up and file a counterblast. After I have gone and participated in the proceedings over there, I have filed revision applications against whatever proceedings that they have initiated against me, my lords. Now I decide to file a counterblast. That's the first limb of my submissions, my lords.
Yes.
Well, the second limb of my learned friend's submission before your lordships is,
yes,
the matter is a dispute which is civil in nature. Now, your lordships are well aware, my lords, of the position of law. That merely because if a complaint, my lords, discloses certain civil aspects of a matter, it may not necessarily mean that merely because I have civil remedy.
Not that. See, like the factual assertion, whatever you have in your complaint petition, that must constitute
a criminal offence. My lords.
Now, just one thing, what is basically court is looking from you is that how do you establish a commission of a criminal act by the petitioner on the basis of the facts stated by you in a complaint petition? Because this otherwise seems like, you see, like these are
supply of substandard material.
Which way? See, like, keep in mind these sections under which this.
My lords, I would have to satisfy your lordship that in the given facts, my lords, a plausible case under these sections can be made out. What I'm
that
humbly
is what
submitting,
this court is more interested.
My lords, I will take your lordship. My lords, I will deal with the individual sections.
Now, in view of your statement in your criminal case, paragraph 6, 7, 8 and 9, which you have referred to in.
Para 7, my lords, they admit that there is some problem. We will rectify it.
That is okay. But then how it becomes a criminal
my
offence?
lords, that establishes that there was some defect.
It's all right.
And failure on the part of the petitioner, my lords, to rectify it would be a deliberate act of supplying me some substandard material, and even after joint inspection, when it is found, my lords, that it is defective,
It will give rise to criminal consequence.
my lords, it is supply of substandard material. That would bring in breach of trust would come in, my lords. If I may take your lordships, my lords, the first is 406, my lords. My lords, may I just take your lordship to section 405?
Yes.
My lords, may I just read, my lords? Whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any person or person so to do commits breach of trust. My lords, I would come in into the latter part of the section. So if I know, my lords, that a certain product is of substandard quality, the purchaser, I present to the purchaser, my lords, no, this is the perfect quality, and if there is any defect, we will rectify it. After that, my lords, it turns out that it is of inferior quality. There is a meeting held. I again assure that we will do the needful, we will change it, and I don't do it. In my humble submission, my lords, breach of trust would at some level come.
Anyway, we would not like to go very deep into the things.
Lordship.
May not be required.
At this stage.
At this stage.
My lords.
But then there has to be, you see, a prima facie satisfaction of the court.
My lords, I bow down.
That is
at this stage of taking cognizance, my lords, it would only be a prima facie satisfaction.
Now, if you say breach of trust, then what was the trust? That is what the main thing.
My lords, the trust is when there is a contract between two people, my lords. It is understood that if I am, my lords, presenting before somebody that I would be giving my learned friend a certain product which is of specification A, B or C, it would be of A, B or C.
Now, there
could be a chance, my lords.
Then it becomes for you to show what he had undertaken, whether he had undertaken to supply you quality A, B or C.
My lords, which is why I took your lordships to paragraph 7. There is an admission on his part. Had that admission not been there, my lords, then the burden would have again shifted on me that probably the materials were of good quality, but I am alleging, my lords, that it is not of good quality. Now, interestingly, my lords, in the proceedings before your lordships, the minutes of this meeting of 12/6/2016 is not annexed. Now, there is a joint meeting of both the parties.
Have you filed any objection to it? No.
We've not filed. 482, my lords, usual practice, we don't.
That is up to you. Whether it is. See, like, if he has not filed something, it would not have deterred you to bring it.
No, true. I quite bow down. I am not on that.
Are you holding it with you?
We have a copy of the complaint before trial? Unfortunately, no, my lords. But it is only for the purposes of showing this, my lords, that
if you want to show, if you say project some imputation of wrong on the basis of non-inclusion of that, then in such a case it would be wise.
I am only on that limited issue, my lords, saying that once I induce somebody to purchasing somebody, my lords, by saying that this is of product A. If your lordships just permit me to draw an analogy, my lords. Tata makes very good steel rods, my lords. I say my product is as good as Tata. And I induce my friend here, my lords, that you buy my rod at this rate for your construction. He buys it. it turns out, my lords, that the rod is not only of bad quality, but in the joint inspection, my lords, which is subsequently held.
If you go by what you are saying,
my lords,
you know how many cases will be there.
Well, it's
Go to the market once. Have you ever done the marketing of those construction materials? Everywhere it is there. It's quite a normal thing.
True.
If you want to buy a lock, they will say this is better than Godrej, in fact. So that is what you see.
No,
so
here, my lords, he is presenting himself as a manufacturer of these media balls. Now we are talking about cement plants, my lords. Now, without these media balls, the clinker cannot be ground into cement. These are round balls, my lords, which are fitted onto machinery, and basically the clinker is ground into cement, and that's how we get the cement as it. Now here, what is happening once the media balls are coming, my lords, they are crushing themselves rather than the clinker being crushed. So what happens is, my lords, as is natural of me, I write to them, please come. We say, please have a joint inspection. They come for a joint inspection. Their representative says, we'll do the needful, we'll change it. Nothing done. And my lords, I am required to suffer a wrongful loss only because some inferior quality material has been supplied to me. I must have some legal redress, my lords. It is true, no doubt true, my lords. I would have some.
You can always go for damages, compensation, many things.
But that would not be a bar for a criminal proceeding.
That is what like this should not be bar. But then again, the criminal proceeding should not be initiated. Just for the purpose of
Well, it's in the facts of this case, it is not. Had there not been the joint inspection, my lords, some questions could have risen in anybody's mind, my lords, that, you're filing some case there, and then one fine day you come here and then you file some proceedings under the IPC. That's not the fact. Fact is, my lords, what is the first reaction? First reaction is we call for a joint inspection. The other aspect of the matter is, my lords, which fell from your lordships, is there was a BWA issued against the petitioners. That's the admitted position. Admitted position is also they have not gone and appeared before the learned trial court seeking discharge of the warrant of arrest and contesting the proceedings over there, my lords. They come directly before your lordships for exercise of powers under 482. The question, my lords, I ask myself is whether they've been able to...
Do not ask, please, you clarify it. Okay. If something remains a question for you, then how this court will answer?
But I cannot but dare ask a question to you.
No, there is no question of asking a question. If you raise certain points, you must clarify it.
But
it should not remain as a question.
My lords, I bow down. Well, what I'm submitting is that whether they come within the parameters of Bhajanlal. Because for your lordships to exercise powers under 482, my lords, they would first have to cross the hurdle of Bhajanlal. So the first hurdle is, my lords, whether the complaint is so, my lords, illusory that a prudent man in his common application of mind would feel that no, this is a
Bhajanlal paragraph 102. There are 10 or 12.
If I may just take your lordship to 1992 supplement 1 SCC, my lords, page 335. Courtmaster.
Have you given a list of books?
Yes,
Paul? Is it there, list of books? It's not there. No, court should have it. Otherwise, I have to write it by hand.
Henceforth, my lords, we'll do that. Because here now we usually just supply it to the courtmaster and goes to the library.
If something gets misplaced, then it will be difficult for me
to
write. And then later you say that the court has overlooked.
Earlier, your lordships, we had that practice of making 4 copies and filing it in court.
If we have the list of books, that helps us.
We'll do it, my lords. Paragraph 102, my lords. It's at page 378.
Yes.
In the backdrop of the interpretation of various relevant provisions of the code under chapter 14 of the principles of law enunciated by this court in a series of decisions relating to the exercise of extraordinary power under Article 226 or the inherent powers under Section 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration, wherein such power could be exercised either to prevent abuse of the process of any court, or otherwise to secure the ends of justice, though it may not be possible to lay down precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula and to give the exhaustive list of myriad kinds of cases wherein such power should be exercised. Now, the first is, my lords, where the allegations made in the first information report or the complaint, even if they are taking on the face value and accepted in their entirety, do not prima facie constitute any offence or make out any case as against the accused. That, my lords, is not there.
That is what? The offence. It's a criminal subject.
Absolutely, my lords. So one side, it should not be something so vague or so absurd that, my lords, anybody would feel it is not possible.
You see, the mere pointing out to certain civil dispute would not constitute, you see, an offence. You see, like, if you say so. Now here the word is used as a word offence. Offence is basically a criminal word. You see, it will be defined in criminal law.
Criminal offence. Where the allegations of the first information or the other materials, if any accompanying the FIR, do not disclose a cognizable offence, justifying investigation of police, not relevant, my lords. Where the uncontroverted allegations made in the FIR or the complaint and the evidence collected in support of the same do not disclose the commission of any offence or make out any case against the accused.
Same thing, more or less.
If it is, my lords, but the relevant word, my lords, which I, in my humble submission, would be important is the uncontroverted. Supposing I am saying something and they do not deny it, whether it would still not constitute an offence. If I am saying, my lords, that media balls are of inferior quality and you have wrongfully deceived me of my money, if they do not controvert that finding also, my lords, whether that itself also will not constitute.
Now, in a CR case,
my lords,
when an accused can go and controvert.
Only after they appear. Only after they appear, my lords.
Then?
Here, admittedly, that is what I was coming to. They choose not to appear before the court, my lords. They come before your lordships, invoking powers under 482.
Now, you want to say that they will have to first appear before the court, they have to controvert it and then they have to come.
What I am saying is, my lords, that the allegations in the FIR should not be so absurd. Your lordships, my lords, if I may.
But then if you are harping on that.
If I may, my lords.
Yes.
There is a matter which was decided by this honorable court. Where, my lords, there was an allegation against a Mr. A that on a certain date he did this. When it ultimately came before this honorable court, my lords, it was found that on that relevant day and a day prior to that and a day after that, that particular gentleman was not even physically present in Shillong, he was somewhere else. And the allegations were, my lords, of 354. So while setting aside and quashing the complaint, my lords, your lordships held that it is absurd. It is not possible. If the person is not here, how can he physically touch you? To that extent, my lords, if there is something, then of course my complaint will fail. My humble submission before your lordships is, in the given facts and circumstances of this case, it is not so absurd. The admitted part is there is a transaction between both the parties. There is the joint meeting, my lords, where they say that we will look into it or we'll change it or whatever it is, my lords. Not done. And, my lords, thereafter, this complaint is instituted. Because 4 is again the same. That's with regard to cognizable offence. 5 is what I'm coming to, my lords. Where the allegations made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent man or prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. If it is so absurd, my lords, your lordships will accept.
Falsity becomes apparent, you see, like that will see.
Absolutely. And 6 and 7, my lords, are again legal provisions, or may not really.
May not be these things. There is a legal war and these things.
7, my lords, I think I should read it out to your lordships. This is where a criminal proceeding is manifestly attended with malified, or where the proceedings is maliciously instituted with an ulterior motive of wreaking vengeance on the accused and with a view to spite him due to a private or personal grudge. That is not the case, my lords.
Counterblast.
Counterblast, I only submitted, my lords, counterblast will come into play only if it is a blast there would have to be a blast and there would have to be a counterblast. Between the blast and the counterblast, my lords, if there is this much of time, then it does not become a counterblast, it becomes another blast. Maybe from the other side.
Now, one thing, after the initiation of those cases under NI Act,
my lords,
you say that there is a gap of
2 years.
Now you challenge it by filing revision.
Lordships, I am contesting those matters over there.
Yes. And those revisions were dismissed.
Well, after dismissal of those revisions, those
when
matters
those revisions were dismissed?
I'm sorry, Malaj?
When those revision
I'll
applications were
get to
dismissed?
2019.
2019. And when this criminal case came?
2018.
This criminal case has been filed 2018.
18.
After hearing.
So it is not that after
I lost it there, then I came and
supporting that.
After it was heard. Then it was fixed for judgment. Then it was pronounced, Lordship, in
2019. So whatever the thing, see your revision applications, those were disposed of in 2019.
Because it was filed in 2018.
So this criminal case has not
come
after this thing. It is not born after the death of those revision applications.
Born after the complaint.
No, born after the complaint under 138. So that cause of action is in 7716.
Immediately in 2018 they've come for revision. 2019 it was disposed of. So in the time being, they lodged the complaint.
So the argument of counterblast and the facts of this case may not really hold water. And I would humbly submit before your lordships, this is not one of those cases where your lordships would invoke powers under 482. Because there is no error in per se in the complaint, my lords, insofar as it being so absurd that it may not happen. Because there was a monetary exchange of money between the parties, there is a commercial activity between the parties, there is supply, my lords. What I'm submitting before your lordships, even though they may deny
whether every breach will constitute criminal offence in a commercial transaction.
My lords, I will humbly submit that a breach.
Today you make supply to me.
My lords.
I undertake I will make payment on certain date.
My lords.
You come and then I do not make. Can you go and file and just, I'll say I will make you the payment after 10 days. Now you do not agree, you go file a criminal case, saying that this is a breach.
If there is your lordships are correct, if there is this 10-day prayer made by somebody, my lords, then maybe at that point of time breach will be there, but it may not be something that can be taken
is it
into
not
court.
say supposing if it's acts and omission, you see, like has the effect of deceiving you,
my humble submission would be any act or omission, my lords, would constitute a breach. Because legally, my lords, strictly, if we are supposed to say it is to be...
No, which way distinguish default and breach?
A default would be, my lords, that if I had paid the money, they were supposed to give me the product within a certain date. And it is not given. They say, my lords, that we would give it after 10 days, 15 days, 20 days, 1 year. Maybe that is a default. If, my lords, a product of inferior quality is supplied to me.
It is not a case that he has not supplied, he has not made any supply.
He has made supply. Supplies of inferior quality. Now, after inferior quality, my lords, he says he will replace it. We wait. Very well. You are my supplier, you've understood my difficulty, please replace it. And then he goes quiet.
He doesn't replace.
So the breach is very much there, my lords. There is a trust. In any contract, my lords, there would have to be a trust between party A and party B. And any infraction of that trust by either of the parties, my lords, in my humble submission, would constitute a breach. Coming within the four corners of 405.
Provided that breach is not accidental.
Provided it is not accidental.
It is intentional.
Provided that it is not accidental. So to prove, my lords, that it was accidental or not intentional is again a matter of trial. That, my lords, in my humble submission cannot be decided in these proceedings under section 482. That is why your lordships have exercised, my lords, self-restraint, if I may put it, while exercising powers under 482.
We have very limited scope to interfere.
My lords.
That is subtle law. But then at the same time, it doesn't mean, for each and every kind of, commercial dispute.
We can go to court. Criminal proceedings can be initiated. Absolutely, my lords, I bow down. Your lordships are...
There are, I think this similar proposition of law is also there. You will find many...
My lords, only one, my lords, I would just place one judgment. My lords, this is 2001, 2 SCC, page 17, my lords. This is the case of Lalmuni Devi versus State of Bihar.
Mr. Paul, I have to note down actually your citations.
Paragraph 8.
1 minute. Just give me 1 minute.
Mallet.
Henceforth, have a cataloged of books. And in this one also today.
Sure. 2001 2 SSC.
Yes, 2001 2 SCC.
2 SCC, page 17. Mallet. Paragraph is paragraph 8.
Para 8.
Mallet. He's already fallen from your lordship, Mallet. Just reiterating it.
Yes.
There could be no dispute to the preposition that if a complaint does not make out an offence, it can be quashed. However, it is also settled law that facts may give rise to a civil claim and also amount to an offence. Merely because a civil claim is maintainable does not mean that a criminal complaint cannot be maintained. In this case of the facts, it cannot be stated. They go back to the facts of the case, Mallet. What I was humbly submitting before your lordships, as your lordships have seen the facts of this case, there is a commercial transaction, there is that. But the factor of breach of trust, my lords, would have to be established or discharged, my lords, at trial. Not at the stage of 482. We cannot, my lord, short circuit the entire process and come before your lordships. If of course the FIR or the complaint was absolutely vague and, my lords, absurd, then nothing could have survived.
Yes.
That's
yes.
One last authority. This is Malus 2005 1 SCC page 122.
What is the relevant paragraph?
No, just bear with me for a second. Paragraph 8. Now it's paragraph 8 onwards. May I read paragraph 8 onwards?
Yes, yes.
Exercise of power under section 482 of the code in a case of this nature is an exception and not the rule. The section does not confer any new powers on the High Court, it only saves the inherent power which the court possessed before the enactment of the code. It envisages 3 circumstances under which the inherent jurisdiction may be exercised, namely, to give effect to an order under the court, to prevent abuse of the process of court, and 3, to otherwise secure the ends of justice. It is neither possible nor desirable to lay down any inflexible rule which would govern the exercise of inherent jurisdiction. No legislative enactment dealing with the procedure can provide for all cases that may possibly arise. Courts therefore have inherent powers apart from express provisions of law, which are necessary for proper discharge of functions and duties imposed upon them by law. That is the doctrine which finds expression in the section which merely recognizes and preserves inherent powers of the courts, high courts. All courts, whether civil or criminal, possess, in the absence of any express provision, as inherent in the constitution, all such powers as are necessary to do right and to undo a wrong in the course of administration of justice on the principles of, I will skip this part. When the law gives a person anything, it gives him that without which it cannot exist. While exercising powers under this section, the court does not function as a court of appeal or revision. Inherent jurisdiction under the section, though wide, has to be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the test specifically laid down in the section itself. It has to be exercised ex debito justice to do real and substantial justice, for the administration of which alone courts exist. Authority of the courts exists for advancement of justice, and if any attempt is made to abuse that authority so as to produce injustice, the court has power to prevent abuse. It would be an abuse of the process of court to allow any action which would result in injustice and prevent promotion of justice. In exercise of powers, court would be justified to quash any proceeding if it finds that initiation, continuance of it amounts to abuse of the process of court, or quashing of these proceedings would otherwise serve the ends of justice. When no offence is disclosed by the complainant, the court may examine the question of fact. When the complaint is sought to be quashed, it is permissible to look into the materials to assess whether the complaint has alleged and whether any offence is made out, even if the allegations are accepted in toto. They've referred to Kapoor, my lords. I will jump. In dealing with the last case, it is important to bear in mind that the distinction between a case where there is no legal evidence or where there is evidence which is clearly inconsistent with the accusations made, and a case where there is legal evidence which on appreciation may or may not support the accusations. When exercising jurisdiction under section 482 of the code, the High Court would not ordinarily embark upon an inquiry whether the evidence in question is reliable or not, or whether on a reasonable appreciation of its accusation would or not be sustained. This is the function of the trial judge. Judicial process should not be an instrument of oppression or needless harassment. Court should be circumspect and judicious in exercising discretion and should take all relevant facts and circumstances into consideration before issuing process, lest it would be an instrument in the hands of a private complainant to unleash vendetta, to harass any person needless. At the same time, the section is not an instrument handed over to an accused to short-circuit a prosecution and bring about its sudden death. The scope of exercise of powers under section 482 of the code and the categories of cases where the High Court may exercise its power under the relating to cognizable offences to prevent abuse of any process of any court or otherwise to secure the ends of justice was set out in some detail by this court in State of Haryana versus Vajanlal. A note of caution was, however, added that the power should be exercised sparingly, and that too in the rarest of rare cases. The illustrative categories were such and such matters, which your lordships have already gone. As noted, the powers possessed by the High Court under 482 of the Code are very wide, and the very plenitude of the powers requires great caution in its exercise. Court must be careful to see that its decision in exercising this power is based on sound principles. The inherent power should not be exercised to stifle a legitimate prosecution. The High Court, being the highest court of the state, should normally refrain from giving a prima facie decision in a case where the entire facts are incomplete and hazy, more so when the evidence has not been collected and produced before the court and the issues involved, whether factual or legal, are of magnitude and cannot be seen in the true perspective without sufficient material. Of course, no hard and fast rule can be laid out in this regard in which the High Court will exercise its extraordinary powers of quashing at any stage. It would not be proper for the High Court to analyze the case of the complainant in the light of all probabilities in order to determine whether a conviction would be sustainable, and on such premise arrive at a conclusion that the proceedings are to be quashed. It would be erroneous to assess the material before it and conclude that the complaint cannot be proceeded with. In the proceeding instituted on complaint, exercise of inherent powers to quash the proceedings is called for only in a case where the complaint does not disclose any offence or is frivolous, vexatious, or oppressive. If the allegations set out in the complaint do not constitute the offence of which cognizance has been taken by the magistrate, it is open to the High Court to quash the same in exercise of inherent powers under section 482 of the Code. It is not, however, necessary that there should be meticulous analysis of the case before the trial court to find out whether the case would end in conviction or acquittal. The complaint has to be read as a whole. If it appears on consideration of the allegations in light of the statement made on oath of the complainant that the ingredients of the offence or the offences are disclosed, and there is no material to show that the complainant is made malified, frivolous, or vexatious, in that event there would be no justification for interference by the High Court. When an information is lodged at a police station, well, it's not relevant for our purposes. In my humble submission, my lords, this would not be a case for exercise of powers under section 482 by your lordships.
Yes.
That's all, my lord. So let trial proceed, my lords. Let them go and appear before the learned trial judge, my lords, they can file an application seeking discharge. That remedy is always open to them, my lords. I cannot advise them, of course, they would know better.
Anything more?
Only to reiterate on the Bhajanlal, I have relied on a decision of 2018.
2018.
Yeah, this is
things are already
there in my compilation.
Your compilation, I think your written argument is
yes. And the judgments also have place, whereby this is a case where they have made some payment towards me. They have made 8 lakhs, and they said they'll pay the balance amount. Though there is some deficiency in service, anyway, we'll pay the balance amount. 2018 squarely covers my case, whereby they say if there's a part payment of it and there's a breach to that, Your Lordship. What does it say? Paragraph 13, 2018, Your Lordship. Reason for non-payment of the balance amount as given by the appellant is that services rendered by respondent company were not in terms of the agreement entered between the parties were deficient in nature. For this reason, even appellant have filed claim against respondent alleging that the appellant suffered loss because of defective services provided by the respondent. And here a plain reading of their complaint, Your Lordship. The grounds which they have taken. Can you see the last paragraphs, Your Lordship, the paragraphs from 11, 12, 13. There's no intention of that sort to constitute an offence of cheating or otherwise. They've vaguely said, they said that they've stated that has cheated and committed fraud. For any offence, Lordship, there has to be an intention, as defined in those sections, Lordship. And the grounds which they have taken are all disputed, Lordship.
No, that is never expected. The accused will go and admit everything.
Never expect.
That will never happen.
Well, normal submission is that this is a fit case, Your Lordship, under 42. There has been prima facie, there has been an abuse of process of court and the manner in which the complaint has been filed, Your Lordship. And Lordship is well aware that in a criminal proceedings, a specific allegation has to be made against each and every particular director or whoever is holding charge. In the instant complaint, Your Lordship, the allegations are general. And I have relied on recent judgments on that also, Your Lordship.
You have given already,
Your Lordship.
The director has been made an accused person here.
The parties rate the director, but there's no specific allegations. It's
Against
the company. You kindly peruse the records of Lordship, the report submitted, because it's in Hindi.
Which report?
The records of the trial court.
The records of the trial court.
Yeah. And the dates are relevant also, Your Lordship. The dates of the orders passed by the trial court.
There is an earlier round of litigation also in this case.
No, Lordship. The jury has been having a lot of litigation all around the place. First order was passed on 30/10/2018.
By the trial court.
Your Lordship.
Wait, just a minute, Mr. (30/10/2018).
Your Lordship. Thereafter, it was fixed on 28/11.
Yes.
Thereafter 10 months, it was listed again on 28/8/2019. After a month of issuing bailable warrant of arrest, on the next month itself, on 11th, 28/11.
28/8/2019. And then this is handed in order.
Yes, Lord.
Case withdrawn to my file and put up today. So in
This is
application of
how it was put up is because certified copies were applied.
So in application for certified
Repair copies.
fact and verified.
Case endorsed to Sri S. Maru for disposal.
Yeah. Repair copies and this is order by whom? This will again endorsed. 28/8/19. This has been again endorsed to some other court.
Shri S. Marwan.
Yes. Now, what you are trying to point out here?
Just trying to point out that on 30/10,
this
bailable warrant was issued against me. It's fixed on 28/11. On 28/11, without any report already issued, they have pressed for non-bailable warrant of arrest.
28/8/2019, there is no this thing.
28, Your Lordship.
28/8/2019, it was endorsed to so and so, and then
28/11, Your Lordship.
28/11 then.
Yes. Some learned counsel submitted that despite BWA being served upon accused person, still the accused person failed to appear before this court and hence pray for NBWA to be issued against the accused person to appear in the next date. From the records, Lordship, no steps was taken. But on the mere submissions,
no, BWA not to be served. It has to go through police.
Can you see the records? Everything is there in the records, Your Lordship.
Very interesting. Well, somebody has applied for certified copies on 28/8/19 and I'm instructed that it has been applied by the petitioner.
Yes, we applied.
So you are very much aware, Malaj, there is a criminal proceeding against you. You apply for certified copies, and then in paragraph 12, Malaj, you make a categorical avowment saying that I am not aware that there is any BWA against me.
Kindly see, I've made
I'll just take your Lordship's paragraph, page 6, paragraph 12, whether your Lordships will still exercise powers under 482.
You see, till the date on which they filed application for certified copy, there was no BWA.
There was, Malaj.
There was.
There was. First order.
Okay. 30/10.
30/10/2018, there's already a BWA. Your Lordships may kindly have a look at paragraph 12.
Yes. No, it is the order should say issue BWA.
Paragraph 12, he says, well, although a petitioner did not have any knowledge of BWA, however, trial court on 28/11 on mere submission of counsel
BWA?
This is after we receive the copies, Your Lordship. That is why we before Your Lordship.
Somebody, my lords, has applied for certified copies.
Paragraph 13 will
apply
clarify.
for certified copies on a certain court, my lords, only when you are aware that something is going on.
Paragraph 13 you will clarify, Your Lordship. The learned friend has read para 12.
But then what bearing it will have in the quashing?
No, Your Lordship.
Well, I am saying that before coming
my only
before
ground
your
is that, Your
Lordships
Why
under
should we get diverted to all those things?
No, my lords,
No,
I am
we
only
should
saying
not.
that when you come before your Lordships under 482, my lords, I also have to come with clean hands. My conduct has to be such that I am the victim. If, my lords, there is something else to be imputed upon my conduct, then your Lordships will not exercise powers under 482.
Done. Okay. Well,
Reserve.
Reserve. No, it's all right. I have to go through the facts. That is the main thing.
I'm grateful for the great patience.
Of light.
Reserve. Right Hearts Planet Councils. So and so and that reserve. Hearing concluded, judgment reserve.
Of light.
Item number 18.